In a ruling by the Supreme Court of Ohio, a person voluntarily putting information into an online marketplace app has no reasonable expectation of privacy, meaning law enforcement does not need a search warrant to access that information. In a unanimous decision, the Supreme Court held that a Columbus police detective's use of a warrantless subpoena did not violate the Fourth Amendment rights of Mamadou Diaw, a man suspected of using the Letgo app to set up a robbery. Letgo provided the detective with a small amount of information, including a single GPS latitude and longitude point. The data point corresponded with a McDonald's in Columbus, which the detective would later learn is adjacent to Diaw's apartment. Diaw argued the use of information from Letgo violated his Fourth Amendment rights against unreasonable searches and seizures. He maintained he had a reasonable expectation of privacy in the data stored on his phone, and the police needed a search warrant to access it. The prosecutor disagreed, saying there is a difference between the information produced by a cell phone when it is in use and the information someone puts in an app.
The driving point in Carpenter was that having a cell phone is indispensable. The decision to create a Letgo account and then to voluntarily log on to the Letgo account is an affirmative choice.
Writing for the court, Chief Justice Sharon L. Kennedy explained the U.S. Supreme Court has developed the third-party doctrine, which states that people have no reasonable expectation of privacy in non-confidential information that they voluntarily turn over to others.
You're arguing that how the data was collected is irrelevant. In other words, pinging cell phone towers to create the pattern of your movements over a series of years versus using a third party to obtain that information about an individual.
As we said very simply, if law enforcement wants to use a cellular user's data inside their phone, they need a warrant.
Having voluntarily conveyed his location to Letgo in the ordinary course of using the app, Diaw cannot now assert a reasonable expectation of privacy in that information, Chief Justice Kennedy wrote. The court remanded the case to the trial court for further proceedings.